Domestic violence is often referred to as domestic abuse because it takes many more forms than just physical violence. Domestic abuse is about power and control. Later stages in the evolution of domestic abuse may include strangulation and battery, but the earliest warning signs may include your significant other obsessively checking your phone, not wanting you to be with friends and family, or being overly jealous. Domestic abusers may use manipulative threats, such as threats of suicide, of hurting or taking children or pets to make their partner stay. Domestic abuse may be a process of escalation, so recognizing the early warning signs may prevent things from getting worse. Abuse is about control, and often the first, earliest step is one partner will attempt to isolate the other from their support system. Abusers may stop you from spending time with friends and family, and may push to move to a place further away. They may obsessively check your phone and monitor your communications. They may take full control of the money and require you to ask permission before spending any money. They may take your keys, your phone, and stop you from leaving the room during an argument. They may call you names and tear you down. They may make fun of you and make you feel crazy when you accuse them of abuse. You should engage law enforcement or your local shelter as long as you feel safe doing so, preferably long before he or she has been physically violent with you. Even if your partner has not done anything that can be prosecuted, law enforcement can help you with safety planning, protective orders, and connect you with resources that can help you escape the relationship. Even simple actions can be prosecutable, such as blocking you from leaving a room, taking the keys, or taking your phone. Domestic violence may escalate to strangulation. Strangulation often leads no outwardly detectable sign, but evidence can be found by those who know what to look for. A victim of strangulation can lose consciousness in as little as 5 to 10 seconds and die within minutes. The chances of being killed by your partner increase 750% if they have strangled you. Let's talk about your rights and what the basic legal processes are. When you call 911, they'll send out an officer to meet with you. When the police arrive on the scene, their first priority is to keep everyone safe, which may include separating you from other individuals if they are present. A lot happens during this first interaction, so here's what you should expect. You have the right to be treated with fairness, dignity, and respect. That applies during this first interaction and throughout the legal process. The officer will take your statement of what happened. The officer will coordinate with the police department to connect you to advocacy services. An advocate is not the same thing as an attorney. Advocates do not represent you in legal matters or give legal advice. They walk you through the process of personal healing, connecting you to resources and navigating the criminal justice system. They are there to answer questions and provide support for you. After taking your statement, the officers will begin collecting evidence. Evidence can include clothing, sheets, video recordings, or anything else involved in the abuse. You have the right to request the return of any personal property taken as evidence after it is no longer needed for the case, should you choose. At this point, Utah Code mandates that police continue the investigation in the interest of your safety and the safety of others that may be victimized by your abuser, even if you decide you don't want them to. At this point, things can begin to get more complicated because there are a lot of things happening in the background on a lot of different fronts. After the report has been made, the police begin investigating your report to gather evidence to present to the prosecutor. An investigator, also called a detective, may be assigned to the case. The time frame of investigating the crime varies, and the process may include interviewing witnesses to the abuse, interviewing the abuser, and other evidence collection. The investigation may involve interviewing witnesses, getting warrants to seize evidence, follow-up interviews, etc. You have a right to a speedy resolution of the case, but it's important to keep in mind the practical limitations of the investigation. It is the investigative team's obligation to investigate all aspects of the event, with the ultimate goal being to find out what happened and be able to provide evidence beyond a reasonable doubt. As the investigation begins, your advocate will work with you on safety planning. Safety planning is exactly what it sounds like. You are making a specific plan for how to stay safe. Every safety plan is different and should cover your response to specific situations. Protective orders can be a powerful tool that comes with civil or criminal penalties if the respondent violates the order. There are several different types of protective orders in the state of Utah, including civil protective orders, sexual violence protective orders, and criminal protective orders. If you'd like to learn more about each protective order or apply for one, reach out to your advocate. Visit utcourts.gov, your local district court, the police, or a local domestic violence center for assistance. Protective orders are an additional layer of protection. Violation of a protective order may result in jail time and/or a fine. Subsequent violations can come with heavier penalties. At your request, the detective on your case may be able to wait until you've obtained a protective order before they interview your abuser. You have the right to be free from threats and intimidation, not only during the investigation, but during the court proceedings as well. After the police have completed their investigation, they present all of their evidence to the prosecutor. Depending on the amount of evidence, either during the investigation or upon its conclusion, an arrest warrant or a summons may be issued for the abuser. The prosecutor represents the city or county where the crime occurred, not you personally. The decision whether to prosecute rests with them, and their priority is public safety, including your own. You have the right to information about criminal justice proceedings and to have those proceedings explained to you. If they decide to prosecute, there are a number of steps before a trial would take place. Most domestic violence cases are charged as misdemeanors, which means once the arrest has been made or the citation issued, the defendant enters their plea of either guilty or not guilty. If they plead guilty, the case goes directly to sentencing. If they plead not guilty, a pretrial conference is held where the prosecution and defense discuss a resolution, which may include a fine, jail, prison, probation, even mental health treatment. The prosecutor and the defense may attempt to negotiate a plea bargain. If they are successful, the case goes to sentencing. If they cannot reach an agreement, the case goes to trial, where the defendant will either be convicted or acquitted. Plea agreements are completely up to what the two parties can negotiate. The law does not require prosecutors to inform victims about plea agreements or seek their approval, though you do have the right to speak to the court regarding any plea offers and be present for important criminal justice hearings. You also have the right to address the court either verbally or by letter regarding the defendant's bail and sentencing. Your primary role in this process, after the investigation has been completed, may be to testify if the case goes to trial. If the prosecutor declined to pursue your case, your advocate and/or the detective may reach out and notify you. Once your abuser has been sentenced, if he or she is sent to prison, then there may at some point be a parole hearing. The purpose of this hearing is to give the defense an opportunity to make a case for why the offender should have their sentence shortened or be approved for parole. Utah law requires that victims be notified of parole hearings and give you an opportunity to testify at the hearing. You will be given 3 to 4 weeks notice that the hearing is taking place, though you may not have an exact time until it gets closer. You are not required to testify at a parole hearing, but your testimony may have a large impact on the decision of the board. If you are not able to testify, the parole board encourages you to write a letter advising them as to the impact the crime has had on you emotionally, physically, and financially. At the hearing, a waiting room that is separate from the offender's family and friends is available for victims. The hearing is open to the public and representatives from the media, though media are prohibited from photographing victims without the approval of both the victim and the presiding official. If you request, the offender can be removed from the room while you give your testimony, though the offender is allowed to listen to a recording of your testimony and respond to it. You almost certainly have more questions, and we'll do a recap at the end of the video. But there are many resources available through the entire state that you can access at any time to help answer your questions and walk you through the process. All the contact information for these resources are in the description of this video or on the webpage where the video is posted. First, the Utah Domestic Violence Coalition has a hotline. They provide information and referrals for people dealing with domestic violence. They offer crisis intervention and safety planning. They're available 24 hours a day and have access to 150 languages via interpreter services. Crime Victims Reparation is a group that assists victims of crime with various expenses. You have the right to compensation for your financial losses in the form of reparations and/or restitutions. Their number is 800-621-7444. VineLink is an automated service for notifying victims about the custody status of offenders in Utah prisons and jails. You can also register to receive automated messages by phone or email when a particular offender is released, transferred, or escapes. You can register at www.vinelink.com or at 866-277-7477. The Crime Victims Legal Clinic provides free legal representation to crime victims when the victims' rights issues are at stake. You can reach out to them at 801-746-1204. The Utah Coalition Against Sexual Assault also has a crisis line you can call. That number is 888-421-1100. UCASA also offers their sexual assault services map and many other resources. Each county also has its own local resources available to assist victims of domestic abuse. Your county's website should have information on these resources. So let's do a recap of everything we've gone over in this video. First, call 911. They will send an officer out to ensure your safety, take your statement, collect evidence, and connect you with an advocate. After this initial report, the agency will investigate the crime, which may require participation from you. The investigation could take time. The detective presents their evidence to the prosecutor, who makes a decision on whether there's enough evidence to prosecute. If the decision is made to prosecute, the prosecution and the defense may negotiate and attempt to reach a deal. If they are unsuccessful, a criminal trial will commence. You can petition for a protective order to prevent your abuser from committing additional violence against you. There are numerous statewide resources and local resources available to help you get through this. Every survivor's journey of healing is different, and they take different amounts of time. Domestic violence crimes are difficult to prosecute. No matter what the outcome of your case, you still have access to resources to help you heal. You are not alone.